for legal and judicial ethics. Okay, this will be about discipline of members, officials, employees, and personnel of the judiciary under Rule 140, which is further amended by AM number 21-08-09 SC. So, let's move forward. So, the proceedings for the discipline of justices of the CA, the Sandigan Bayan, the CTA, and judges and personnel of the lower courts, including the Sharia courts, and the officials and employees of the Office of the Jurisconsult, Court Administrator, Deputy Court Administrator, Assistant Court Administrator, and their personnel may be instituted motu proprio by the Supreme Court in the Judicial Integrity Board. So, that's how it is, no? Through the Judicial Integrity Board. And it may also be instituted, number one, by way of a verified complaint, supported by affidavits of persons who have personal knowledge of the facts alleged therein. Number two, by authentic documents which may substantiate said allegations or upon an anonymous complaint supported by public records of indubitable integrity. Or number three, where their material averments may easily be verified and may be substantiated and established by other competent evidence. So, complaints involving graphic corruption and violations of ethical standards, including anonymous complaints filed against members of the Supreme Court, shall be referred to the Committee on Ethics and Ethical Standards, which shall have the task of preliminarily investigating and submitting its findings and recommendations to the Supreme Court and Bank, in accordance with the internal rules of the Supreme Court. So, what are the grounds? First, you have the misconduct. Misconduct implies a wrongful intention and not a mere error or judgment. For serious or gross misconduct to exist, there must be reliable evidence showing that the judicial acts complained of were corrupt or inspired by an intention to violate the law or were in persistent disregard of well-known legal rules. So, the commission of two or more administrative offenses alleged in the same administrative complaint may aggravate the offense and render the same serious, which will warrant the dismissal of the judge from the service. So, example, regarding the case of anonymous letter complaint against Judge Samson, 2017 case. So, when respondent Roque applied for the position of utility worker 1 in her court, respondent Judge Samson knew that he was not yet discharged from probation, and yet she recommended respondent Roque for the position in a recommendation letter, which forms part of the employment record of respondent Roque in the court. So, her act violates Canon 2 of the Code of Judicial Conduct. Okay. Number 2 is gross ignorance of the law. Okay, let's take the case of Balanay versus White. So, respondent admits allowing Adama 6 consecutive furloughs to attend regular sessions of the Sangguniang Bayan of the Municipality of Oras, Eastern Samar, based on very urgent motions that did not contain notice of hearing and were not heard in open court. Thus, citing in Villanueva vs. Judge Buaya, therein respondent judge was held administratively liable for gross ignorance of the law for granting an ex parte motion for bail without conducting a hearing. So, a TSN or transcript of stenographic notes is supposed to be a faithful and exact recording of all matters that transpired during the court proceeding. Respondent's act of directing her subordinate to alter the TSN by incorporating their statements pertaining to substantial matters that were not actually made during the hearing constitutes gross misconduct. Number 3 is gross inefficiency. So, like misconduct, inefficiency as a ground for disciplinary action must be serious or one which is weighty or momentous and not trifling. So, negligence in the performance of duty, if reckless in character, could amount to serious or inexcusable inefficiency. So, that's it. Now, let's go to the sanctions imposed by the Supreme Court on erring members of the judiciary. So, for serious charges, we have 11. For number 1, bribery, direct or indirect. Number 2, dishonesty and violations of the anti-graft corrupt practices under RA number 3019. Number 3, gross misconduct constituting violations of the Code of Judicial Conduct. Number 4, knowingly rendering an unjust judgment or order as determined by a competent court in an appropriate proceeding. Number 5, conviction of a crime involving moral turpitude. Number 6, willful failure to pay just debt. Number 7, borrowing money or property from lawyers and litigants in a case pending before the court. Number 8, immorality. Number 9, gross ignorance of the law or procedure. Number 10, partisan political activities. And number 11, alcoholism and or vicious habits. So for less serious charge, there are 7. Number 1, undue delay in rendering a decision or order or in transmitting the records of a case. Number 2, frequent and unjustified absences without leave or habitual tardiness. Number 3, unauthorized practice of law. Number 4, violation of Supreme Court rules, directives, and circulars. Number 5, receiving additional or double compensation unless specifically authorized by law. Number 6, untruthful statements in the certificate of services. And number 7, simple misconduct. And we also have light charges. Okay, there are how many? 4 only. Okay, so number 1, vulgar and unbecoming conduct. Number 2, gambling in public. Number 3, fraternizing with lawyers and litigants with pending case or cases in his court. And number 4, undue delay in the submission of monthly reports. Okay, so if the respondent is guilty of a serious charge, he can be dismissed from the service. Also, forfeiture of all or part of the benefits as the court may determine, and disqualification from reinstatement or appointment to any public office, including GOCCs. Provided, however, that forfeiture of benefits shall in no case include accrued leave credits. Suspension from office, without salary and other benefits for more than 3 but not exceeding 6 months. So, yun din pwedeng penalty, if serious charge. Number 3, pwede rin yung a fine of more than 20,000 but not exceeding 40,000. Kapag less serious charge naman, pwedeng suspension from office without salary and other benefits for not less than 1 month nor more than 3 months. Or a fine not more than 10,000 but not exceeding 20,000. Kapag light charge naman, pwedeng fine not less than 1,000 but not exceeding 10,000. And or pwedeng kasama ang sabay. So pwedeng may censure, reprimand, or admonition with warning. So those are the important provisions for the upcoming bar exam, and I will not anymore include the video for practical exercises, as you can just search for it in the internet on how to draft these legal documents. So that's it for the discussion of legal and judicial ethics. I hope you learned something from this video. And again, this is just a bar review lecture. So as you can see, I'm trying to read my notes. So another disclaimer: these are not my personal notes, but the one I bought from a reviewer, or as a reviewer. Sorry. Okay, so that's it.